Even the removal of power mattered. If the president could dismiss federal officers without giving cause, we would have, Calhoun said, a base and servile civil service. Calhoun noted the dangers of presidential patronage, adding that where the president can dismiss at his will and pleasure, he would gain an imperial power. And in talking about this whole question, Calhoun counts the Army as part of the presidential patronage, so it's sort of an anticipation of a military-industrial complex. It's rather timely with all the business of the U.S. attorneys serving solely at the whim of the president and so on. We've been hearing this lately. Okay, now we probably still have the question, why presidential legal doctrines matter? Well, it matters first because acceptance of these claims by legal professionals, by politicians, by the public, will lead to further assertions of such powers and use of them, and more of the war-courting policies we have seen since at least 1950. Further, the more the president can appoint judges who are carriers of unitary executive theory, the more he can finish transforming the courts into another arm of the executive, so that no check will come from that quarter. So new doctrines will create the foundations for a new legal regime and shape what the courts will enforce and what they will ignore. Where judges are concerned, we must not be misled by an artful confidence trick. Recent judicial nominees have widely advertised their views on abortion and states' rights, while downplaying their commitment to the unitary executive theory, arguably the most important item in a package deal. I don't know why this is a package deal, but it is. Senator Biden saw through it in the case of Judge Alito, as did Professor Lawrence Tribe and some others. If unitary executive claims spread through the system like a virus, further subordinating Congress and the courts, the last stage in our own regime change will be at hand. We shall have a system of vast and irresponsible power, centralized, grasping, and ultimately vulnerable to the crises it generates and represses. Although I suppose we could say we're pretty far along at this moment. We cannot treat the unitary executive theory, then, apart from the policies of which it is both a symptom and enabling act. And so we come to empire and its sundry costs. Would we be as concerned if the war had gone well? I hope so, but I can't say. Had the war gone well, new gains for arbitrary power might have gone unnoticed or less noticed, but it's not gone well, and this focuses our attention. And the costs to which I refer include lives lost, money squandered, new enemies made unnecessarily, and a sense of national pessimism. But there are additional moral and institutional costs. This is the wider sense of the term blowback. The American presidency has become a serial war initiator. Empire, constant war, and emergency regulations march in lockstep with presidential power and patronage. It is futile to treat one and not the others. If we wish to maintain or restore the rule of law, our essential liberties in a republic, we must confront what the presidency has become. We may find ourselves preferring lethargy, sloth, openness, and slow, careful deliberation in the executive in place of the much advertised energy, speed, stealth, and decision. So essentially, I think we face a republic in crisis of the sort the 18th century writers went on about. And we'll have to resolve this one without the Machiavellian ventriloquism of establishment conservatives. So we face a number of questions. How can we reverse the corruptions of institution, law, and language? Can we play the constitutional record backwards? Can we disunite the unitary executive? One proposal that I've seen is to, if it were feasible, I suppose the crisis will have to really reach an interesting point before anything could be done. There's no reason the president should be appointing an attorney general. I mean, the one we have now is, well, just probably proves the case, but there's got to be some other way to have these important officials put in place, not beholden to the president. This works well enough in the States where there's separate elections for a whole array of top state officers who are not considered inherently executive and therefore subject to the unitary governor. There's other models to look at. So can we disunite the unitary executive? And that also goes to the question of who is actually sovereign around here. I mean, it's peculiar that the unitary executive theory derives presidential powers over foreign affairs from the very king whom we were deposing. Apparently, the people are only sovereign in the unimportant area of domestic politics. It's a very strange thing to have a legal fiction of popular sovereignty, but have the executive deriving his foreign affairs powers directly from the King of England. Now, I want to leave you with a real signing statement. This was signed by people that were really signing something. In the ratifications of the Constitution by New York, Virginia, and Rhode Island, the convention stated that the powers granted to their new agent could be resumed or reassumed, there's two spellings, resumed when perverted to the oppression of the people. Now, perhaps the unknowably large emergency powers actually reside here, or perhaps they reside in the amending power. Thank you.